Hi guys, welcome back to my channel. So today in this video, I would like to read an article entitled The Continental Shelf, the Exclusive Economic Zone, the Philippine Rise, they are not Philippine territory. Comments on the National Territory Provision. The Consultative Committee has presented to President Rodrigo R. Duterte the draft federal constitution. Below the some comments that may be made in respect of the provisions on national territory contained in the draft that has been released online. Article 1. National Territory. Section 1. The Philippines has sovereignty over its territory, consisting of the island and waters encompassed by its archipelagic baselines, its territorial sea, the seabed, the subsoil, and its airspace. It has sovereignty over island and features outside its archipelagic baseline pursuant to the laws of the Federal Republic, the law of nations, and the judgment of competent international courts of tribunals. It likewise has sovereignty over other territories belonging to the Philippines by historic right or legal title. Section 2. The Philippines has sovereign right over the maritime expanse beyond its territorial sea to the extent reserved to it by international law, as well as over its extended continental shelf, including the Philippine Rise. Its citizens shall enjoy the right to all resources within these areas. The Philippines has sovereignty over its territory. The formulations provides emphasis but likewise reveals the circular statement of the concept of sovereignty and territory as element of the statehood. As we know, in addition to people and government, a divine territory and sovereignty over such territory are the elements that compose a state. Thus, having sovereignty over its territory seems to say little insofar as stating the extent of national territory. The phrase operates to describe the nature of the right of the state, which is essentially a given. In any case, this sentence is supplemented by the clause consisting in the island and waters. Thus, the extent of such territory is defined by making the archipelagic baseline the points of reference, as well as the suboil of the land features and the subjacent airspace are considered part of the state's territory. When and where the Philippines shall define the extent of its territorial sea, which is limited only to 12 nm, remains to be seen. The problem, however, is the inclusion of the territorial sea in the sentence as though it was within the archipelagic baseline. Such an idea is factually incorrect and legally insupportable, given that the territorial sea of an archipelagic state is measured from the archipelagic baseline seaward following the 1982 United Nations Conventions on the Law of the Sea, or LOSC. It appears sound that archipelagic baseline are made the reference point is defining the national territory. The waters encompassed by said baseline are thus deemed archipelagic waters, through which foreign vessels enjoy not only the right of innocent passage in the territorial sea, but also the more controversial right of archipelagic sea land passage. Within the archipelagic baseline are archipelagic waters, without the archipelagic baseline up to a maximum distance of 12 nautical miles that form is the territorial sea. It has sovereignty over island and features outside its archipelagic baseline pursuant to the laws of the Federal Republic, the law of nations, and the judgment of competent international court of tribunal. It can be asked whether the sentence describes a. the extent of national territory as the article is supposed to provide, b. the legal basis on which the claim of territory is being made. It seems to reflect the latter. The mentions of law of nation, a concept not free of ambiguity, deserves some attention as well. What exactly is referred to as law of nation? A concept defined by many writers including Vattel, Crucius Milhobbes et al. In fact, the term is regarded as archaic and modern usage already replaced by customary international law. It is understood that the part relating to the judgment of competent international courts or tribunal is mentioned in recognition of the sojourner arbitral case between the Philippines and the People's Republic of China or PRC. As can be observed, this sentence appears to have been taken from Article 38 of the International Court of Justice stated, which is understood as providing for the sources of international law. Thus, this bolsters the observation that the paragraph functions more as explaining the sources of Philippine territorial claims under the federal constitution rather than defining its scope. More importantly, if the drafter of the provisions have to the SCS arbitration case in mind, then there seems to be confusion between issue of sovereignty and maritime entitlement. Over the former, the arbitral tribunal had no jurisdiction and consequently could not and did not address the same. It appears that the sentence concerned the Federal Republic adherence and or reference to international law and rules or norms arising therefrom, and is not quite a description of the extent of national territory. The consultative commit properly exclude the continental shelf and the exclusive economic zone or EEZ from the scope of Philippine territory. They are not part of our national territory over which the Philippines has sovereignty. The authority for this statement is the international law, particularly the LOSC, on which the Philippines as a matter of fact anchor its case against the PRC in the SCS arbitration case. The LOSC is crystal clear that the sovereignty of the coastal state extends to an adjacent belt of sea described as the territorial sea, and to the airspace of the territorial sea as well as to its bed and subsoil. Sovereignty does not extend to areas beyond the territorial sea, in example, the continental shelf and the EEZ. This is not to say that the Philippines is giving up its right in relation to these areas. It is up to recognition of international law and its regime on maritime entitlement. An example, sovereign right per the laws. Clearly, between sovereignty which applies to territory and sovereign right which apply to the conventional shelf and the EEZ, there is a huge difference that should be considered. Less diplomatic tensions between states is caused. It likewise has sovereignty over other territories belonging to the Philippines by historic right of legal title. It is understood this sentence refers to the Philippine claim over North Borneo and state the basis of such claim. Section 2. The Philippines has sovereign right over the maritime expanse beyond its territorial sea to extend reserved to it by international law, as well as over the extended continental shelf, including the Philippine Rise. Its citizens shall enjoy the right to all resources within these areas. This section is supposed to be an assertion of sovereign right possessed by the Federal Republic. For emphasis, such statement is permissible for may be necessary, especially in view of our adherence to international law. Likewise, it reveals the selective appreciation of the nature of right possessed by states in the maritime zone beyond the territorial sea, given that only sovereign rights are mentioned without other jurisdiction, with the other rights such as exercise of control and jurisdiction. Again, for emphasis, the mentions of the Philippine Rise is understandable. But what about other areas is reference to which we have or may have a right to establish the limit of another continental shelf as well, without meaning to undermine the importance of the Philippine Rise and our successful establishment of the limits of an outer continental shelf in said region. The reference thereto seems superfluous. After all, the article does not mention Boracay Island, Camotes Sea, and the like. in reference to the island and waters within the Philippine archipelago. So that's all the article. Bye bye and see you on my next video. Bye!